So again, welcome to the Tribal Law and Policy Institute's Healing to Wellness Court final webinar of the Adult Healing to Wellness Court series. My name is Angie Juarez Monger, and I'm a Wellness Court Specialist with the Tribal Law and Policy Institute. Thank you for joining us today for Do's and Don'ts of Healing to Wellness Courts, Lessons Learned. So just a little bit about TLPI before we get started. TLPI is a Native American operated nonprofit and is dedicated to providing free publication resources, comprehensive training, and technical assistance for Native nations and tribal justice systems in pursuit of our vision to empower Native communities to create and control their own institutions for the benefit of all community members for now and future generations. So part of our training and technical assistance work is to offer training that will support the implementation and enhancement of healing to wellness courts. And webinars like this are one of the ways that we support this. Today's presenters, Judge Torres and Cayla, along with their other team members of the Bernalillo County Metro Court's Urban Native American Healing to Wellness Court, have presented on behalf of TLPI and several other trainings and conferences over the past few years. Their Healing to Wellness Court has been distinguished as one of TLPI's founding mentor courts in TLPI's Mentor Court program. They have been a mentor court to other Healing to Wellness courts who are implementing or enhancing their own Healing to Wellness court. The Urban Native American Healing to Wellness Court team has also been awarded TLPI's first Tribal Healing to Wellness Court Team Award. So without further ado, I will turn it over to our esteemed presenters for today, Judge Renee Torres and Cayla Sanderson.
Welcome, everyone. We are very happy to be presenting on our program today. We're happy to have everyone join us today. My name is Cayla Sanderson. I'm the program manager for our Healing and Wellness program, and I'm going to start off with our learning objectives. So today we're going to learn about the Urban Native American Healing and Wellness program we have here at the Bernalillo County Metropolitan Court in Albuquerque, New Mexico. We're going to examine and discuss our program evolution and the ways that we have evolved throughout the years, and in doing so through the lessons we have learned and through our implementation of best practices, both through All-Rise and then also the 10 tribal key components that we follow in our program. We're going to discuss program integrity and sustainability. These are two very important components that we practice in our program, and we can't have one without the other. So we felt it important to discuss integrity and sustainability. And we are also going to discuss continued program improvement. As a program, we never get comfortable with what we're doing. We're always striving to do our best and meet participant needs for better outcomes. Here's a picture of some of our team members. We have a great team. I'm just very proud to be a part of our Healing to Wellness. And this was taken actually after one of our days that we had here at the courthouse last year. So our team is made up of our presiding judge, Renee Torres, who is co-presenting with me today, myself, the program manager. We have our lead worker, Brianna Zubia. We have two probation officers, Ariana Chavarria and Caroline Dixon. We have our case manager, Vicki Johnson. We have defense counsel with the Law Office of the Public Defender, Jody Barron. And we have Heather Holmes, who is our prosecutor, or who was our former prosecutor, and now we have Marcus Gibson. And we have Tanya Rabinowitz as our First Nations Behavioral Health Director. Jared Lee is with our Traditional Wellness program. He is the coordinator of that program. And then we have cultural care providers as well.
And are you all having a hard time hearing us?
Yes, Judge Torres and Cayla, I was going to tell you, Cayla, when you were speaking, it kind of fades out a little bit. So I don't know if it's a microphone that you might be using, but it just fades out kind of at the end of your sentences.
Okay.
And then the other thing I wanted, to mention is there's just a tiny bit of a delay on the slide, so it just takes an extra second there to change.
Okay, we'll try to speak louder so that you can hear us. Do you think that's better?
I can hear you perfectly fine, so maybe that's better.
Okay, and hopefully our internet connection is okay. I also saw a message in the chat that maybe we're breaking up a little bit. Are you getting that, Angie?
I think it was the fading in and out.
Okay, so we'll try to, we're both sitting in front of my monitor, and so we'll try to lean in a little bit when we're speaking so you all can hear us. And let's move on to the next slide, please. Good morning to everybody. I'm Judge Renee Torres. I'm from the Pueblo of Isleta. I've been presiding over the Urban Native American Healing to Wellness Court for about 9.5 years now. I started my 10th year at Metro Court, and I'm very proud to be and honored to be presiding over this court. It keeps me connected to my Native community, and so I'm very proud of our team as well and our participants for all the hard work that they're doing. We believe that team unity is one of the most vital things to our success of the program. And so we maintain, we really work hard to protect our team unity, to avoid issues of triangulation. Sometimes participants will do this. There's different things that can happen to affect team unity while, throughout the program. So to prevent that, we make sure we have good regular communication by email, through staffings, planning meetings. We have annual team retreats, and that can just be two. This year we have one in January. It's just 2 half days where the team's going to meet to go over some planning and do some team building exercises. We have quarterly planning meetings that we try to regularly do. Sometimes we get off track with those a little bit, but we try to keep our quarterly planning meetings scheduled. We mutually respect each other's roles. We make sure that there's training for all team members, including onboarding training specifically for each role, as well as the treatment court best practices, evidence-based theories, all the pertinent information that each team member needs to know to be part of the team. We keep that frequent communication, like I said, by email, and typically as a whole team, we communicate. I don't allow any team members to contact me directly by email. If they send me an email directly, I ask them to resend it to the whole team, because I believe that there should be transparency among the team, and all team members should be aware of what's going on with our participants and anything going on with the program. Let's see here. We also do training in areas of, therapeutic modalities, cultural sensitivity, the roles of the team members, and we all have a common goal, which is to best serve our participants to meet all of their needs to support their success. And we didn't state what our mission statement is, but I'll let Cayla do that if she wants to read that out loud to you all real quickly so you can hear what our mission statement says.
Our mission statement is for our Urban Native American Healing to Wellness Court program is to create an atmosphere of healing for self-identified Native Americans through best practices and traditional methods in pursuit of spiritual and physical recovery from alcohol and other substances.
And, we all have different roles on the team. Like I said, we all have that common goal. And sometimes there might be times where we might not agree on everything. As long as every team member is heard and gets to express their point of view, sometimes we have to agree to disagree on something. But usually we can reach a consensus and then move forward. So again, we believe that team unity is vital to our success. Our next slide, and there is a delay is what I've been told, but our next slide is based on, it's called program evolution. And these are the reasons our program has had to evolve over the last 8-9 years. And I'll go over the first few, and then Cayla will go over the last ones. We have had to evolve to address participant needs as well as their health and well-being. We've seen participants who they come into the program, they haven't been taking great care of themselves. And so they do a health and a wellness assessment at the beginning when they first come in and do intake. But sometimes their health changes after a few months being in the program. So we usually do a 6-month reevaluation of their health and wellness assessment so that we can uncover any issues that might be coming up and get our participants any referrals for healthcare or anything like that that they might need. We've had to evolve to improve chances for success for our participants. We've had to evolve to adhere to best and evidence-based practices and to comply with state certification requirements. There's a certification process here in New Mexico for all treatment courts through our administration of the administrative office of the courts. And so we have to meet those certification requirements also. So we'll talk more about some of these other things, some of these things I just mentioned in detail as we go along, but these are some of the reasons we've had to evolve, and I'll let Cayla talk about the last few.
So we always, through our evolution, we have to address negative trends. We go through this periodically in our program. I'm going to touch on a few. These are just a few of what we've seen as far as negative trends go. And then a little later on in our presentation, I will go into further detail. But some of the negative trends we have seen are dilute tests. This is always a point of contention, and just, it can be conflicting with participants because they are not valid tests. We don't have, a alcohol test in front of us or a positive drug test in front of us. So it's easier for them to be dishonest with the court and the program with dilute tests, and it's always a work in progress, and we're always leaning on our treatment team to see how we can best address dilute testing with participants. Another negative trend is the honesty piece. We're constantly having to juggle best practice standards, it being a proximal goal, with also understanding the psychoeducation of learned behavior of dishonesty, trauma, all those sorts of things. So, it's trying to help them get to a place of them being honest with themselves more so, than the court, so we can best serve our participants. Program integrity is another trend that we've had to address. It's very important to our program to have integrity, and we always have to be on our P's and Q's, in noticing behaviors from participants that could negatively impact the integrity of the program. Also, we've had some challenges with domestic violence histories with participants, as well as mental health needs, and they don't always disclose or present with certain behaviors that tell us that they are in need of a higher level of care that we cannot provide to them in the program. So then we're having to kind of play catch up while they're in the program and try to figure out how we can best serve them. So it's just really important that we're screening participants properly to get them where they need to be. And lastly, recidivism. It happens. Our recidivism rate is a little above 5% for our program, which it's good for a program of our size. However, it's never, a good feeling to have participants who have completed our program and they end up with, even felony subsequent DWI charges. So we're always looking to improve and see how we can improve our recidivism rate. Next, through our program evolution, we've increased participation with our traditional wellness component. At one point, it was not mandatory for participants to attend traditional wellness groups. However, this is the basis of our program, the cultural component, and Judge Torres felt that it was necessary to make it mandatory because participants were not really taking advantage of what the cultural piece of our program is offering them. So as soon as it was made mandatory, now we have participants who go more than is required, and our traditional wellness team, kudos to them because they do a great job in an urban setting to meet the cultural needs of our participants. And Also, we have evolved in our pro-social activities. We more recently recognized the importance of helping our participants understand what a pro-social activity is and to put that into practice so that that plays into their long-term recovery journey.
And I want to add a couple more things. We believe it's always important to reevaluate how we're doing as a program and to make changes as needed. Our policies and procedures are a living document, so we're constantly updating them to reflect any changes in policies. And we want to put any changes to our policies in writing, so we make sure we're documenting those and updating participant contracts as well. So we're constantly updating and revising our policies and procedures to reflect these kinds of changes. And our next slide, we're going to discuss program challenges, and Cayla will start.
So just as any treatment court, we do face our challenges. There are, other challenges not mentioned on this slide, but these are the ones that really stood out to us and that have had the most impact on our program. So the first being the screening of potential participants program acceptance. I mentioned this previously with domestic violence participants, and they don't usually come in presenting with those kinds of behaviors. And so it just makes it hard for us to know that those needs exist, and they're initially not always upfront with probation or even their attorneys prior to coming into the program. And so then, as I stated previously, they're in our program, and unfortunately, we've had instances of participants picking up very serious violent felony charges, and then we're having to reevaluate and say, well, what did we miss during the screening process, because they could have potentially been placed into a DV treatment court. And so the same goes for mental health participants. We run into instances of participants having mental health needs that exceed what our program can offer them. And so we've really tried to implement policy and procedure to mitigate the chances of setting people up to fail in those instances. And it's very important. We've learned to communicate with our team regarding these cases, especially our treatment team, because they're the ones that are providing those treatment needs. And we need to know if they're going to be able to, have that individualized treatment for our participants, and we want our participants to be successful. Also, non-readiness for change in treatment. Again, we have to understand per best practices that our participants at the very beginning stages, especially in phase 1 and 2, there's a lot of change and adjustment. We're really trying to focus on getting them stabilized in those early phases. And however, where it becomes challenging is when like phases 3 through phase 5, they're still exhibiting certain behaviors, or they're being obstinate or defiant with the program. It makes it difficult to try to meet them where they're at. But we, as a program, that's one of our main priorities, is to individualize our treatment and meet them at. And so if we're not addressing these behaviors sooner rather than later, then that's playing into recidivism, and more than likely after the program, unfortunately, these behaviors will continue. So we just have to really make sure we're addressing these in the earlier phases, in phase 1 and phase 2. Also, dilute test results. As I stated, these are a point of contention, and it just makes it very difficult to pin down what the need is with participants when we're getting dilute test results. This dilute test results take a lot of effort on the part of the participant, because they are drinking a gallon or more of water 90 minutes before their test. This is what the research is telling us. And I would highly encourage everyone in this webinar to utilize Paul Carey's research. He's a a national expert that we utilize. The name of the document, and we could put it in the chat as well, is the use of creatinine concentrations for abstinence monitoring and treatment. I highly advise anybody working in a treatment court or in probation to read that document, as it gives great guidance on how to address dilute test results. Also, we found that it's very important to be consistent in how we're responding to dilute tests, and not wavering from that, and not colluding with the behavior, because this goes back to criminogenic thinking with dilute test results. So it's always a work in progress. I know Judge Torres saw a need to how we were approaching this. When I first came on, we were ordering them to do research papers on how not to get a dilute, but we realized that that's colluding with the behavior. We're pretty much teaching them how to get a dilute test result. So now we moved away from that. And Judge Torres, it doesn't matter what phase they're in, they're getting community service, try to curb that kind of behavior. And as I stated, please refer to that document. We can put it in the chat as well. And it's also on the All Rise website. Also, we have the challenge of honesty and accountability, curbing criminogenic thinking. So again, as I stated, it's the earlier we can address that, the better with participants. It's not easy being in probation and sitting there and they're not being honest with you, and you have a positive test in front of you or dilute, but we also have to sit back and remember that they're going through a lot right now. They have mental health needs that are being addressed, and so again, we have to have empathy for that as well, and really lean on our treatment provider to give us guidance. And what's really worked for us is MRT, which is moral recognition therapy. And that helps, with true reflection. It is an intensive group for them. And initially they kind of, view it as a punishment, but as they move through that curriculum, a lot of them really appreciate what it offers to them. And I think that in itself really does help with our recidivism and them being able to hold themselves accountable.
We've had participants who, throughout the program, in different phases of the program, it doesn't matter what phase they're in, but that try to compare their treatment recommendations, their sanctions, their everything that they're doing in the program to other participants. So we frequently try to promote the concept of individualized treatment, sanctions, that everything in the program is individualized for that participant. I will frequently tell participants that they have different challenges and obstacles than another participant, and so they're on their own journey. We don't compare them to each other, and they should not be comparing themselves to each other also. And so we've had that issue of and then that goes to program integrity also. Sometimes participants will try to collude with other participants, and if they're not happy with the program or with probation because of some of the challenges they're having, they try to collude with other participants and compare how their probation officer is treating them, or sanctions, or how the court is delivering sanctions to what other people are getting. And so we try to address those early and often, and to also express that everything is individualized. The sanctions, the service adjustments, any accommodations that we make, that we're meeting the participant where they are at individually. In the last few years, so we have the transition to life after the program, let's go back to that slide, reducing recidivism. We've had participants graduate and within a year pick up a new DWI charge, like Cayla was saying. And that's despite us really trying to hammer into them that we are still here to help them after they graduate the program. They can contact anybody on the team. They can contact anybody at First Nations, which is our treatment provider, and that they're always welcome back to contact us for anything that they need. So despite that, we still have participants that may pick up a new DWI charge after they've graduated the program. We also seen challenges of when our participants give their graduation speech, we weren't having great graduation speeches. They weren't really very in-depth and just very surface level. And it's been a while now, but we developed an outline that the participants are required to follow in preparing their speech for graduation. And that has helped tremendously. And there's only 3 requirements: that they discuss where they were before they came into the program, their journey throughout the program, and goals for themselves that they've set for themselves after the program. And we get the best speeches now from our participants, and and they really dig deep and share a lot with us in their graduation speeches. A lot of the team has been brought to tears lots of times because of what our participants reveal and express at their graduations. And I really believe that the graduations are not just for the participant that's graduating, it's for the other participants as well, to keep them motivated, on track, help them see the light at the end of the tunnel, help them to relate to how they're feeling right now in the program, and to kind of alleviate some of those fears and just what they're going through, the overwhelming feeling of being in a program that there's light at the end of the tunnel and other people have gone through some of the same things they've gone through. So really setting the expectation higher for graduation speeches, I think, is important. And we've had people tell us that our participants give the best speeches of all the other treatment courts. So we love hearing that also. And then again, we're going to hammer hard on program integrity. We're always constantly addressing issues that affect program integrity. And so some of you might be wondering, well, what is program integrity? What do you mean? It's not necessarily easy to define, but you will know it when you see it. All of you who are in treatment courts see different behaviors from participants that we know it's affecting the success of our program. It's affecting the success of other participants. It's affecting how the team works with each other. We find that some participants will try to triangulate, tell treatment one thing, tell probation another thing, or complain about their probation officer to their counselor or their treatment provider. And we view those as attempts to disunify or break up the unity that we have as a team. And every team member values the unity that we have. So that's why we keep our communication strong and open. So anything that participants are doing that is disrupting the function of the program, including disrespect to team members, disrespect to probation officers, not engaging in their groups as required. And when you have a participant that's in a group and they see other participants not engaging, then they start to think, well, why do I have to participate if they're not participating? So, and that affects the integrity of the program when we're not pushing and requiring participants to engage in treatment and in group sessions. And so our treatment providers, our traditional wellness program facilitators will keep an eye on how much they're engaging. And sometimes our participants won't get credit if they're not engaging as required in their groups, because it is required for them to engage. Sometimes participants try to drag other participants down with them if they're not doing well. Participants try to talk their way out of following treatment recommendations, trying to negotiate with the treatment provider about why they can't maybe do IOP, or why they don't want to do this additional group that's being recommended for them because of the needs that are being seen. Anything that negatively affects the function and success of the program goes to program integrity. Like I said, when you'll know it when you see it, even though we can't necessarily sometimes put our finger on it. Those are things that are affecting program integrity. And we can go to the next slide. Cayla, did you want to add something?
No, Judge, I think you did a great job of covering all of that. So next we're going to talk about the program changes that we have made throughout the years. This seems to be a very short list, but there's been many changes that we have made. Again, these are the ones that stood out to us. So as I've stated Actually, I don't think we covered this yet. So we do have a health and wellness assessment. I do believe Judge Torres did touch on this previously. So initially, there was just one health and wellness cultural needs assessment that's completed by our traditional wellness program. And so as time has evolved, there was a need for a reassessment after 6 months, which is usually halfway through the program. Our program's usually about a year. Some participants go a little over that. Some participants are in a program, I believe, up to 3 years. It just depends on where they're at. So needs evolve, needs change, especially when they get sobriety under their belt. They start noticing things, health needs that they need, anything of that sort. We're very lucky to have First Nations because it's almost a one-stop shop. You know, there's case management, there's health, eye, dental, a whole array of needs that can be met there. And I believe because they're in our program, they get priority for appointments, which makes it really nice. So it's just important that we're meeting the needs throughout the program. And so this was implemented, and I think it's been a great tool for us. Also, we've changed contracts to address disruptive behavior or non-engagement in any part of the program. This is holding everybody accountable. And so what we were running into was disruptive behavior, participants falling asleep, they're on their phone, they were not engaging, and it wasn't in their contract. So what probation was getting from participants was excuses about, well, you know, no one told me I couldn't, you know, be on my phone or I couldn't sleep. So this is holding them accountable. And if we see any of this going on, we can refer back to our phase contracts and say, well, you agreed, you signed your contract agreeing to engage and not be disruptive and not be on your phone, because again, that goes back to integrity of the program, and it can be very, you know, detrimental to the progress of other participants in the program as well. So, and I do want to highlight that starting phase one, this is the language we're using with them so that they get used to this. And also participants requirement to submit the graduation speech, like Judge was speaking about earlier. So we do have a nice outline for them, and I think that's been really effective in them being able to really reflect. And also what I appreciate about our participants during graduations is that they're vulnerable. It's not easy to be vulnerable in that setting in front of their peers. And there's things that we find out about our participants that we had no clue about. And they don't have to, you know, provide that or speak about that, because sometimes it's very personal matters that they have in their speech. And I just appreciate how vulnerable they are. And like Judge Torres said, I mean, the word around the courthouse and with attorneys and stakeholders in the community is that our graduation speeches are very great, and we're really proud of that. And that's all because, you know, of the need that Judge Torres saw of, you know, having that outline and getting them to really reflect.
And okay, Cayla's going to continue. Go ahead, Cayla.
So continuing with changes, this is more specific to the phase requirements. So we're always trying to follow best practice standards. Obviously, when we're doing our policy and procedures and making changes to our phases. So, and these are just a few of the changes we've made throughout the years. So phase one was reduced from 90 to 60 days. The whole idea behind this was they have a lot going on. We're throwing a lot at them, and we wanted them to experience a win, as we call, early on in the program, because this builds confidence in their ability. Like, hey, I'm doing this. I made it, you know, 60 days, and we want to be able to advance them earlier instead of, you know, having that 90 days. So, and that seems to be very effective in our program. Also, employment not being required in phase one. It was at some point a requirement. However, again, there's so many requirements that they have to get done in phase one. They have a lot being thrown at them. They are overwhelmed. So we felt it appropriate in order for them to be able to manage everything, to not require employment. So it is that requirement starts phase 2 through phase 5. Also, restarting sobriety dates for dilute tests. Previously, we were not holding the participants, I guess, accountable in this way with their sobriety date, because if they had a dilute test, they didn't have to restart those sobriety days. So this is another way that we can deter that behavior.
If I can add, I think that also goes back to the honesty and accountability. When we were not restarting the sobriety dates for dilute tests, a participant could, instead of submitting a valid test, which would probably come up positive, they would take efforts to subvert the test and drink a lot of fluids before their test so that we wouldn't see a positive test. And so instead of getting a positive, they got a dilute, which did not result in restarting the sobriety days. And so then we were somewhat enabling them being dishonest with the program. So now that we have to restart their sobriety dates for dilute tests and positive tests, then we get down to, why are you not being honest? Because providing a dilute test is just not being honest with the program. You're taking active efforts to, I guess, mess with the result of that test. When you drink a lot of fluids within 90 minutes of a test, that's an effort to subvert that test result. Right, I'm sorry.
Thank you for that, Judge. So yeah, we're at every step of the way we're trying to deter that criminogenic thinking, especially with dilute tests. It's just, again, it's a really tough negative trend that we see from participants, and we always have to be one step ahead of our participants when it comes to this. Also, change from aftercare phase to phase 5. Again, we're staying within best practice standards with this. Terminology in every aspect of the program is super important. We have to make sure that we're not duplicating, I guess, treatment terms when it comes to this. Phase 5 is not a true aftercare phase, so we just have to be mindful of the terminology we're using. So we did change it to phase 5. Also, they do have to do at least one traditional wellness session per week as required. And again, that's the cultural aspect of our program is one of the key components that we have, and that really supports their sobriety, not only now, but long-term. So they are required to do one traditional wellness session per week. And as I stated, they often do more than that. Also, pro-social activities and peer support groups required in phases 4 and 5. That's a more recent change that we've made. And again, it's because we saw a need for this. Peer support is lived experience. It's a huge part of what our program does. We have a wonderful case manager who did come up with a pro-social activities calendar that she sends out every month. And it has so many different activities within the community that our participants can engage in with their families, their friends, and pretty much the work's done for them. Sometimes it can be hard to find these activities, but our case manager does that for them. So they really just have to show up, and they do have to provide proof to us that they did attend activities. And also, I do want to highlight our alumni coordinators. We do have alumni groups. When I first started with the program, we had 1 or 2 alumni coordinators. Now we have over 12, I want to say. So that really, grew within a short time frame, and they are such an integral part of providing support to our participants, because they have lived experience, and our participants will tend to listen more to them because they've not only have recovery, but they've also participated in a treatment program. So we're really proud of that.
And I want to add also that our pro-social calendar was initiated by Healing to Wellness Court. And now all the treatment courts in Metro Court use that pro-social calendar, because pro-social activities are encouraged while anybody's in a treatment court, changing those behaviors from going to activities that involve substances or alcohol to pro-social activities. So the calendar includes lots of things that are free for participants to go to within our community. So we're trying to, get them really involved in those. And so we're really proud of the team for doing all of that, and our case manager.
And also another highlight of that calendar is our case manager will announce at court sessions and encourages participants to submit any artwork. So that can be jewelry, if they like to cook, they can send pictures of the things that they're making, any positive activity that they're involved in outside of the program. She encourages them to submit, and we incentivize that as well. We give them credit. They can get community service credit, or they can get self-help credit for that. So it's a really awesome way to boost their confidence as well.
Our next phase is addressing non-compliance. I saw there was a question in the chat about what we do for positive drug tests. So there's a difference between willful non-compliance and issues that participants are having achieving or maintaining sobriety. So we just wanted to highlight these, what we do for as court sanctions. And court sanctions are for willful non-compliance and just a participant not meeting the requirements of the program. And those things can be missing appointments, missing a test, lack of engagement, dilute tests. I see dilute tests as being both a willful non-compliance because they're not providing a valid test, and it's also a therapeutic issue because they're not able to achieve or maintain sobriety. And so that one is kind of a dual. So when we see willful non-compliance, these are the court sanctions we typically give. And when I first started with the Healing to Wellness Court program, I think being a judge with this kind of a program, you want to try to be consistent and be fair, but we all know that you can't treat every participant the same. They're all in different phases. They have different obstacles, different challenges. So we tried using a sanctions grid for a while, and that just didn't work. So we don't do that anymore. Everything is individualized. And so we try to do what's best for that participant, even when it comes to sanctions. So I'll impose community service, which is sometimes weed and litter, or it can be in an agency. If you're having to do weed and litter, then that's a more punitive sanction. And those that can be for repeated dilute tests or repeatedly missing tests, restarting their sobriety date for each phase or for the phase they're in. Is for dilute tests and positive tests. In-office reprimands for lower level violations, then the court will just allow probation to do an in-office reprimand with the participant. Travel is not allowed for the first phase of the program, but after phase 1, participants can request travel outside of the county, even outside the state. We usually limit that to no more than 4 days. But they can't even leave the county, go from one county to the other unless they get permission. So if they're not in compliance, then we suspend travel authorization for at least a month. And so, and we look at that. For court hearings, the people that are on our all-star board, that means a participant has not had a violation from one court hearing to the next. They're on the all-star board. And and if you're not on the all-star board, you get called last. So everybody on the all-star board from phase 5 all the way down to phase 1 gets called first. And if you're not on the all-star board, you get called last, which means people in phases 5, 4, 3, 2, 1, they get called after everybody on the all-star board. So that's somewhat of a sanction as well. And on the other side, the flip side, it's an incentive if you're doing well to get called first for phase transfers and being on the all-star board. So we have the sanction and the incentive as well. So we can also impose increased testing. We impose the SCRAM device for repeated dilute tests and repeated positive tests, increased court hearings and probation visits, meetings with the case manager. That's sometimes not necessarily a court sanction, but something to help the participant get some help with time management, help with finding employment, help with referrals, seeking out services from outside agencies, filling out applications for other different types of services that they might be able to receive. So meeting with a case manager isn't always just a sanction, it's something to help the participant. And then the service adjustments are for positive tests. And we know that sobriety is a distal goal when our participants come into the program. That's something they're working towards. So we require the treatment provider recommends a behavioral chain analysis, and that's a process that participants go through with their therapist in reflecting about what triggered them to either have a relapse, what that behavioral chain was that led to their relapse, and they go over that with their therapist. We do treatment modifications based on the recommendations. So sometimes they're recommended to do MRT if they're not already doing it. Sometimes it's intensive outpatient, the outpatient program, IOP, seeking safety as well. Sometimes there's a recommendation for inpatient treatment, recommendations for peer support groups if the participant is struggling, and we see certain instances that might require more peer support. Maybe if they don't have a lot of support, maybe family members, friends that they're relying on for support, we'll try to steer them towards peer support groups as well. Group adjustments, depending on whether they're how they're doing in their group, something might need to be adjusted. Medically assisted treatment referrals, if participants are continuing to have positive tests and triggers and can't control their urges to use alcohol, we'll do the referral for the medically assisted treatment. Then it's up to the participant whether or not they want to take the medication. We'll do psychiatric referrals if we're seeing any concerns about cognitive issues or mental health issues. We'll do a referral. And again, it's up to the participant if they want to get on any kind of medications that might be recommended. And then we'll refer them to any outside agencies for other services that they might need. So again, there's a difference between willful noncompliance and then service adjustments that have to do with repeated relapses and their ability to abstain from using alcohol and other substances. Let's see here. So sometimes, and we don't do this often, it's not on the list, is a court sanction can be jail time also. And jail time is only given when there's violations of law. If a participant in the program picks up a new charge, a DWI, they're most likely going to get terminated from the program, and they may be held in jail if they're picked up on the new DWI. They might be held in jail until they're sentenced. But jail is only given for if a participant is driving without the ignition interlock device. That's a violation of law and a violation of the program requirements and conditions. They cannot drive unless they have the ignition interlock device installed. If they pick up new charges, it could be a traffic violation, it could be anything. We've had participants pick up domestic violence charges while in the program. If it's not another DWI, there's a chance that they can still stay in the program and just get some kind of a sanction. But if it's another DWI, they are likely 100% being terminated from the program. So that's a non-negotiable. So again, these are how we address non-compliance in the program.
So next, we're going to discuss the lessons learned, and it's regarding the incentives that we've implemented throughout the program. I just want to highlight this picture here. I think it's an awesome picture. We have our probation officer, Ariana Chavarria, with one of our graduates here putting his name on the plaque. So those are always great moments. They're really proud to be able to do that in the program, and it signifies a very important part of their life. So we're always very proud to, have these moments in our program. So the incentives that have worked for us have been participant praise. This praise comes from judge during court sessions, if we have feast days that we hold for our participants, and then also treatment, provides praise to our participants' traditional wellness when they come meet with probation. We're constantly giving them that encouragement, even if they are struggling in the program. Yes, we need to address these behaviors or this positive test. However, these are the things that you are doing good in the program. and rely on those strengths that they have, despite any difficult times that they're going through. Also, we have an all-star board. So what this is we have a big whiteboard that we bring to every court session. We put participants that have had no violations since their last court session. Their name gets put on this board. Their name is put in a drawing, and we draw prizes. They get to play Plinko during the court session. If their name is drawn, they come up, they play Plinko, and then we have different prizes. We give out community service hours, virtual appointments, gift cards, gifts that we get donated to the program. So it's just a really awesome way to highlight all of their hard work that they're doing in the program. And they really strive to get their name on that board. So that's a huge incentive that we have in the program. Like Judge had touched on, travel requests, those usually get granted if we're seeing consistent noncompliance or they're struggling. There have been a few times where we've had to deny those, but normally they are granted. We want to be able to support positive support with their families. They usually like to travel with their family, take a break. We all need breaks, so this is a great way to give that to participants. Phase advancement certificates, the piece of paper, but it's so important to them. We've noticed that they really strive to get these certificates, and it's very important to them. A lot of the times they save these certificates and are very proud of them. So it's a very simple way to encourage participants in the program. And as I stated, they do get to put their name plate on the honorary wall of graduates. As I stated, it's just an awesome way to acknowledge all of their hard work since being in the program. So, and those all work very well for our participants. And next, we're going to discuss incentives and sanctions that did not work for us. So at one point, our participants in phase 1, they could attend virtually for any sanction hearings that we may have. However, we found that this is a very crucial time for participants in the program, and we found it important that they're coming in to see Judge. Yes, they are having to come in and maybe adjust their work schedule. However, it's just important for Judge to have that interaction with participants very early on. And so now they are required to come in and, answer to anything that's going on, such as a positive test. And Judge always does a great job of encouraging them. Yes, this is happening right now, but you're going to get through this. You have the team here to help you. And again, giving them that praise. Also, there was a point in time where they were able to skip a court session or probation office visit as part of an incentive that they won, being on the all-star board. However, they were using that to their advantage in various different ways. And so we really need every office visit is important. Can't be missing these with participants because we can miss something very important going on with our participants. So we've modified this. They do have to come to every court session and probation office visit unless they win on the all-star board to have a virtual visit. Also, again, as I stated previously, they were having to write papers on how to avoid dilutes. We quickly realized that we're colluding with that criminogenic thinking, and so this is no longer a response to dilute tests. And also, we always need to impose sanctions sooner rather than later, and I think we do a very good job of that. We have sanction hearings twice a week in front of Judge Torres. That's on her docket, so that we're getting these addressed, and treatment can respond in the way that they need to, probation can respond in the way that they need to, and then they can move forward. So next, obviously, probation is a key part of our program, and these are the lessons that we've learned in supervising participants in Healing to Wellness. So first, communication is key. And if we're not communicating frequently with our wellness court team, we're missing something. And that's, we don't want to set our participants up for failure. And it's our job to make sure that we're paying attention, we're on our P's and Q's about what's going on with our participants. And if we're seeing something, that's being communicated to the entire team, because what probation may be missing, treatment may notice something, and then we can work together to come up with a solution and for better outcomes for participants. Also, providing extra structure and support in phases 1 and 2. Again, these are the most important phases in the program, and just being extra supportive and helpful, building that rapport and trust with participants is very crucial during this time. And getting that trust from them, I think, really helps them be able to be successful in these phases. Also, balancing empathy with intensive supervision, especially with probation. I feel like they look at us as the authority, and they do not trust us. So, and our team does such an amazing job of having empathy with participants, even if they're struggling. We're taking that time and we're sitting with them. There's plenty of times where I have 1,000,001 things I have to do, but none of that matters if I have somebody in my office who's really going through something, and I'm going to take that time and just sit with them and be there for them. And I think that they appreciate that. And also, just communicating, hey, you know what, you had a positive or you missed a probation appointment. There's an accountability piece to this, but that doesn't change, that, we're very proud of you still. We're always going to be very proud of you. And a lot of the times our participants have never heard that in their life, that someone's proud of them. So just that word, being proud of them, it goes a long way. So we just really have to be very mindful of our body language too, not working on the computer while we're meeting with them. Our attention is solely on them, and they really appreciate all of that. Also, being attentive to subtle changes to participant demeanor. A lot of the times, this leads into them disclosing very difficult things that they're going through. And so there's been plenty of times where I get to know participants. They're sitting in my office and they come in and they're very short, and I'm asking them, how are things going? And they're just giving me one-word answers. And that's usually not their demeanor. And I'm just say, hey, I noticed there's something different, going on today. Can you tell me what's going on? And usually they'll just, lay it all out and say, hey, yeah, I'm going through a lot right now. So it's just very important to be mindful and pay attention to participants. Also acknowledging that cultural needs are equally important. We must be culturally competent when we're working with our participants, and, having our training. And also, I learn a lot from our traditional wellness coordinator and our cultural care providers. They, always remind us of, cultural needs, and it's a great way for us to, be on top of our cultural competence when working with our participants. And understanding, that traditions are sacred, and if they're allowed to partake in their traditions, and we're asking, well, how did everything go? They tell us, well, I can't talk about that, and we have to respect that and be knowledgeable that that's very sacred for them. So I think cultural competence is key here.
So again, we're going to go back to program integrity again and the sustainability of our programs. And I went into a little bit more of a discussion about what we believe program integrity is. And I'm sure all of you have seen different issues and things that come up in your programs that affect program integrity. And we just think it's super important to always be on a lookout for anything that's affecting our program integrity. So we always try to make sure that we're addressing any criminogenic behaviors that addressing any issues where participants are not taking accountability, whether it's for a test or some kind of behavior. We've noticed that misery loves company. If one participant is not happy, they try to get banned with other participants to kind of have kind of somewhat of a revolt against the program or the court or the team or whatever it is, or it could be against a probation officer or a treatment provider, something like that. So we're all, our participants are going through a lot of challenges, and they're in the program having to confront trauma and, their substance use and their addiction. And we know it's not easy, but we still have to, we can still have empathy and address these issues and have high expectations for their behavior in the program. And we should, because other participants are watching, and when it affects the morale of other participants and their success in the program, we take that very seriously, because we don't want one participant dragging other participants down with them. We accept only high risk, high need candidates. So that comes with a lot of challenges. And we used to have a low risk, high risk, low need track at one point, and we no longer have that. We only have high risk, high need, and we see the big change in this population and how high their needs are. And let me see here. We've made sure we put these prohibitions in the policies and procedures and the contracts. So again, like Cayla said, to put our participants on notice early on in the program of what's expected of them. We redirect participants who encourage criminogenic behaviors among each other. We monitor incidents of triangulation. And our team, like I said, communicates really well with each other. And we have treatment and our traditional wellness program team members telling us when a participant is complaining about a probation officer, about something else or whatever. So we keep that communication open. And so when there's trust among the team, they'll share those things so that we can know about them and address them and keep an eye out for them. We prohibit our participants from engaging in inappropriate behavior. Like we were saying, during court sessions, during group sessions, during anything that, that involves other participants, and even just one-on-one with a probation officer. Participants aren't allowed to be disrespectful to the probation officer. They might not agree. They might not be happy at that point. They might be struggling with something, but that does not give them permission to be disrespectful to anybody on the team. We work really hard to treat our participants with empathy and with respect, and we expect that back from them. And so we also redirect participants who discuss sanctions in group settings or try to steer their group conversations to something involving the program. And we've had treatment providers let the team know that so-and-so was complaining about this during our group, and it took the group off track, off the topic they were trying to discuss that day. So that's not allowed. That's not okay. And the facilitators of the groups are on notice that they cannot allow that kind of behavior during the groups, because that's not what the groups are there for. So we make sure that we're on top of those kinds of things. Even participants speaking negatively about the program, the probation officers, treatment, that creates havoc within your program. So always keeping on top of those and addressing those early on is really important. Otherwise, those things continue and it wreaks havoc in your program and it festers. And if you don't call out a participant early in the program and you call them out maybe in phase 3 or 4 or 5 later phases, then they're kind of puzzled, like, I've been acting like this the whole time. Why are you now just bringing it up? So we don't let that happen. We've learned that we can't allow those things to happen early on. We have to set those expectations early on in the program. Again, some of the integrity issues also are the dilutes, the dishonesty, non-engagement, disrespect, some of those things that we already talked about. Let me see here. When we talk, and we were talking about sanctions earlier about, everything is individualized. What's fair for one participant isn't necessarily going to be the same for another participant. It's not the same for everybody. So we have to learn how to explain that to our participants and explain to them why they're getting a certain sanction or why something is happening. And if we explain to them, they begin to understand and not be resentful towards the program. So we have to protect the functioning of our program, our participants' well-being, being compromised by other participants, the success of individual participants. Again, this is really important, and those are some of the lessons that we've learned, and we've kicked ourselves later on in the program. And like when we're looking back at something and trying to figure out why that happened with a participant, certain participant, we say to ourselves, and we talk among our, as a team, we should have acted on this earlier on in the program. So we're trying to help you all head off some things. And, we've gone through a lot of different challenges in our program, and we always want to be operating at the optimal levels. And we think all of that is important. Okay, go to the next slide.
Next, we're going to discuss adherence to best practices. Obviously, this is a huge, what we should be following in our programs. And so we're meeting participants where they're at. It's individualized, like Judge Torres has touched on. There should be no cookie cutter approaches with participants. They all have different needs. They all have different circumstances that they're going through. And again, we're really constantly telling them, do not compare yourself, because you don't know what another participant's going through and all of those things. So we're meeting them where they're at. There's been plenty of times, especially like with mental health needs, we have to tailor the program to their needs, and just asking for basic, showing up to appointments, showing up to court hearings is really the most that they can do in the moment. And that's all we're asking them to do. So that's huge. Also, limit jail time to no more than 6 days total throughout the entirety of the program. So if this isn't followed, the recidivism chances go way up. So this is very important for us to abide by in our program. The whole time I've been with this program, I believe we've only had one participant stay longer than that, just because they had picked up on a domestic violence charge and they were being held on that other case. It wasn't because we were holding them. Also, individualized treatment, conveying this often to participants, like I stated previously. And also, this not only applies to treatment, but also sanctions. Those are individualized as well. And oftentimes what happens is participants are in the same sanction hearings as others, and they are wondering, well, I got a dilute and this person got a dilute as well, but I got treated differently. Well, there's different circumstances and different needs, and we're constantly communicating this to them. There's holistic delivery of services. Again, we're very fortunate to have First Nations that allows us to do this for our participants, meeting all of their needs with one provider. And then also, we're lucky enough to be in an urban setting where we have different resources in our community. So, and they are expected to follow any recommendations, and that's in our contracts as well. If they're referred to an outside agency, they are expected to follow any recommendations of that agency. In-office praise and incentives, again, we're adhering to that. We're adhering to the sanction incentive ratio that we must meet, and we have our own database where we're keeping track of all of that. We audit every phase change to ensure that we're staying on our P's and Q's. We're meeting every part of best practice standards that we should be with our participants. Addressing compliance issues timely. As I stated, Judge has court hearings twice per week. She opens her docket to that, and Judge will go through, if she has any hearings prior to our problem solving hearings, she hears those first, because part of the sanction is, waiting in court. And so that's one way we try to deter them from violating or being defiant in any way. Also, communicating proximal and distal goals. Judge does a great job of doing this, throughout the program, in court sessions, at sanction hearings. She's constantly using this language with them so that they understand what goals they should be meeting now and what they're working on throughout the program.
Our next slide is adherence to state law. In 2024, New Mexico legalized the recreational and medical cannabis use. And so it's treated as, if you have a medical cannabis card in New Mexico, it's treated as a medical prescription like any other prescription. So prior to this law, we did not accept individuals into our program that were using medical cannabis. And so now we cannot deem somebody ineligible for our program if they're using medical cannabis. So we were required to take them into our program. And at that time, when we were first learning that we were going to have to do this, it caused a lot of anxiety and stress among the team about how we were going to handle this. And there have been some changes and different program requirements for these participants. We've had to revise our policies and procedures to put in there any kind of behaviors that a participant might be exhibiting, that they're high or not engaging in their groups or showing signs of being under the influence of medical cannabis. They can use it, but they cannot go to groups or sessions or anything under the influence. And so, and if that happens, that we can have a hearing on that, they can be written up. And so, but we are required to accept these participants. Now we closely monitor these participants, their engagement in the program, and they must attend a trauma-informed group as well. That's an additional group that they get through the treatment provider. And it addresses their underlying issue, the reason why they are on the medical cannabis. So, and we've had some participants who have decided to stop using medical cannabis while in our program, and it's happened in later phases, and we really praise them, and we're just so proud of them when they finally do that, because they're not relying on another substance. And I think that's what our huge concern was accepting these individuals, was that they're able to use another substance while in the program instead of abstaining from all substances. But we've had a lot of participants stop their medical cannabis use while in the program. And I think that is our goal, is to try to get them to stop using it so that they're not using any substances, but we still have to accept them into the program. We don't get federal funds for our program. We only get we only get state funding. And so we're able to do this. I know that all healing to wellness courts don't just rely on tribal or state funding. They rely on federal funding. So you all might have different protocols and policies, but in New Mexico, we are required to, if the participant is otherwise eligible and they're on medical cannabis, we are required to take them into our program.
And I would add to that too, there have been instances where we have participants who are using their medical cannabis card. They come into probation and they really smell strongly of marijuana. So, we have to also be mindful of peers and people that may be triggered by that smell. So we have those conversations, please don't use before you come in, because it makes the whole hallway smell of marijuana, and we don't want to trigger peers or anything like that, and just be respectful of your peers. Also, we've had incidents of them coming to court smelling of marijuana, and it just makes the whole courtroom smell like that. So it's just being mindful of those things as well, because we also want to respect the participants that are not using medical cannabis as well.
There was a question in the chat about tribal jurisdiction to legalize THC or medical marijuana. I don't know anything about that, but what I do know is that tribes throughout the U.S. are considered federal land. So marijuana is still prohibited on federal land. So it's not a federal law. Cannabis has not been legalized federally. So, okay, we can go to the next slide. I think we're getting close to our time, and we want to maybe allow some time for questions.
So
let's just go through this.
Oh, yes.
So quickly. Go ahead.
So we're always, like I said, looking to improve what we're doing in our program, and I think that, that's helped us out a lot. We're always focusing on honesty, integrity, and accountability in our program. We focus on phase objectives per new standards. That's something new that we're working on and revising how we're setting up our phases for participants. It's not checking off boxes, really anymore. It's really focusing on the treatment aspect of what they're doing in our program. Careful screening of potential participants. Again, we need to make sure we're getting the right participants in our program, that we can set up for success and have better outcomes. Getting them in the right program, whether that's our program or a DV treatment court or a mental health court. Also increase peer support throughout program. Again, I highlighted our alumni group, and also, there's other peer support resources we have in the community that they have access to. Issues concerning high-risk, high-need population. Judge did speak about the importance of, not doing harm to participants that are lower need, and we found that it's a hard group, but we're constantly having to remind ourselves that they are high risk, high need. They need these services, and we're doing everything possible to give them the treatment that they need. Morbidity risks among population. Unfortunately, we have a lot of family deaths, health issues our participants experience, and while they're in the program, and we're happy we're here to provide that support to them and help them work through that grievance and all of those things. So we're constantly, and a cool thing that we do is that we have sympathy cards that we hand out to them anytime they lose a family member. That's just our way of just trying to show support, and Judge will excuse participants if it's needed to be able to spend time with their families and support them. Also, obtaining criminal history from tribal jurisdictions. We're always looking to improve upon that, because what happens sometimes is they're not disclosing to us that they have pending tribal charges, and it's impeding their ability to be successful in the program. And so we're always looking for ways to, work and network with our, tribal colleagues to get that information.
And if I can just go through a quick list of some do's and don'ts, just generally, and then we'll open up for questions. So these are some of the really important things that we do in our program. We treat our participants with respect and empathy. We hold our participants accountable and require honesty. We promote team unity. We protect program integrity. We evolve as needed within best practices. We address issues early on, trying to avoid enabling behaviors and bad habits. We praise our participants as often as possible. We acknowledge their struggles and try to problem solve as a team to help them wherever they're at. We attend as much training as possible on treatment modalities, cultural practices, motivational interviewing. There is a significant learning curve when you first start with a treatment court, and we're always learning. And I've been with the program 9 years now, and I'm still learning. We document any changes to our protocols and our policies and procedures and contracts. We acknowledge that each participant has different struggles and challenges. We focus on building life skills and good habits. We focus on individualized treatment and services. We address alleged violations as soon as possible. We don't want to ever shame our participants. We don't want to compare them to each other. We don't discuss their personal information in court sessions. We discuss amongst the team, and we all sign confidentiality agreements. We don't expect perfection from our participants. We don't accept excuses for dilutes. And I'm very clear about that. 0 excuses for dilutes. We don't wait to address issues that are negatively affecting the program's progress and function. So those are just some big things that we focus on. But we can open it up for questions. Did you want to say anything else, Cayla, about any of those?
No, Judge, I think that was
okay.
Great.
So we can open it up for questions now. We're happy to answer any questions that you all may have. Are we able to see anybody that's can we open it up to view our attendees?
Judge, they can raise their hand and Janice can unmute them so the question can be asked verbally. But there were some questions in the chat. You already addressed the tribal jurisdiction and the legalization of marijuana. Someone's asking, what is your recidivism rate?
Our recidivism rate is a little above 5% right now. as I stated, that's a good recidivism rate for a program of our size, and we're always trying to get that, lowered to the best of our ability. So anytime there's recidivism, it's hard, but we're always working to improve upon that.
And we don't have a law enforcement team member right now. We've had one in the past, but we're seeking to get another one. We do have MOUs with the district attorney's office for their team member, and for the public defender attorney, the defense counsel that's on our team. There's MOUs with them. We do have a contract with First Nations, who's our treatment provider. So there's a 4-year contract with them. So we do have contracts and MOUs in place with people that, agencies we work with.
And there was a question about that, Judge, and the follow-up question to that would be if you are able to share those MOUs or MOAs as examples.
We're willing to share any documents that we have, including our policies and procedures. You can just contact Angie or Janice, and we're happy to send that information to you. There was another question. We have how many participants do we have right now? 30 something?
We have 33.
33 participants with a cap of 50. We have 2 probation officers, a lead probation officer, and Cayla's our program manager, but she's been carrying a caseload for a while because we've been short-staffed. So hopefully soon Cayla will be able to not have a caseload, but our cap is 50.
Okay, we got another request for if you could share your policies and procedures, Judge and Cayla. So if you're interested in getting any of these documents that we're talking about, just put your email address inside the chat. We can send those as a follow-up to you individually. There was a question about the slides. We can share those. You'll get a follow-up email after the webinar that will share the slides, and it'll have a little reminder for evaluation if you didn't get to do that here in just a minute when we bring up the code. So we will be able to get those to you. Thank you. I see all the emails coming in. Judge, there was one more question. I think you may have answered it. It was a question about sanctions for positive drug tests.
It's different. It depends on whether it's a first, second, third. I mean, well, we really don't give sanctions for those. It's just restarting the sobriety date, and then there's a service adjustment. So there's not a sanction for positive tests, but for the dilutes there is, because there's a dishonesty and an accountability component to that of them subverting the test. And we do suggest that you all look at that All Rise document. The use of creatinine to monitor abstinence has a lot of good information. We've given that document to defense attorneys as well, because we get various arguments throughout when we have court hearings to address dilutes. I hear crazy arguments sometimes about why somebody got a dilute, and really there's no excuse. Reason for dilutes is too many fluids or liquids 90 minutes before a test, and so that's not okay. So it's not the time of the day you eat. It's not eating too much protein or not enough protein. And there may be like issues with kidney function or other specialized areas, but we would require a doctor's note if there's repeated issues like that. But chances are your participants have provided lots of non-dilute tests. And so we also somewhat track their creatinine levels. So if they normally have a creatinine level of 180 or something like that, and it goes down to 15 or 10, or, the cutoff is 20 for a dilute. So anything below 20 is a dilute test or sample. And so we really don't accept any excuses anymore.
Thank you, Judge. There was another request. Could you provide a sample of your pro-social calendar for your participants?
Yes, and I guess the way our case manager did this is she basically does a web search for our whole community, the Bernalillo County, within the area of Albuquerque, to see what's going on in the city or the town, or even there might be other things going in tribal surrounding tribes, but whatever, she just does a web search and puts it all down on a calendar. But we'd be happy to share it. It's a document that's emailed. It's a link that's sent to all our participants. We used to print it, but it's too many pages long. So now it's a link that they can go to.
Thank you, Judge. One of the things, as I highlighted at the beginning of the webinar, is that Judge Torres and Cayla's court is one of our TLPI mentor courts. So I think this further justifies, we've been wanting to add a mentor court section to our wellnesscourts.org website. So I think this would be helpful to be able to share some of these documents and post them online for other healing to wellness courts to use as a model. So we'll proceed with that. There was another question that just came in. Please continue to type your questions and we have a couple more minutes. I am going to move to the evaluation slide. So you have some time to do that, but you can still enter your question. You can still raise your hand. But the question, Judge, is how many counties are included in your area for your court?
It's just Bernalillo County, but that's a huge county. It's a metropolitan area of Albuquerque. So it's a huge county. And I don't have the numbers in front of me, but Bernalillo County is huge.
Thank you, Judge. So on the screen now, you will see the QR code to complete an evaluation. If you could please complete that, we really appreciate getting feedback on our webinars. And just to close out, before everybody leaves, we just wanted to thank you. Here is our TLPI information. If you go to our website, you can find a link that has all of our training materials. You'll find a link that has our wellnesscourts.org publication series. The wellness@tlpi.org is our direct email address if you'd like to ask the presenters any follow-up questions or want to request any training to us directly. You can send an email to wellness@tlpi.org. And I just wanted to take a second to thank you, Judge Torres and Cayla, for sharing your experiences with us. We appreciate your time to be with us today. And thank you to everybody for joining us for our final webinar in this Adult Healing to Wellness Court webinar series. We hope that you found our presentation today helpful and useful to the work that you do every day in your own Healing to Wellness Court. And please join us for our other webinars that we have later this month and in February and in March. Thank you, Judge. Thank you, Cayla.
Thank you, everybody.
Have a great day, everyone.
Thank you.